in order to ensure that communities are informed about the laws and fundamental rights entrenched in the Constitution, involved in high school social events in order to improve academic development in local communities, involved in the Keep That Gold Shining, which empowers youth, uplift local communities, socio-economic development, and sustainability in various communities, involved in various studies such as international business, trade in law in line with customs that exercise law, and involvement of tax law through international jurisprudence. So let us clap hands for him, guys. And he's also qualified in Master's Law, LLB Master's Law, Bachelor of Arts in Criminology, Bachelor of Arts in Forensic Science and Technology, Bachelor of Science in Information, Communication and Technology. Let us clap hands for him, guys.
Thank you so much. Can I use my voice without using my mic? Okay, so my name is Ivan Toral Mashavu. I'm from Pretoria. I'm a lawyer by profession, but before I became a lawyer, I was a crime analyst at SAPS, South African Police Service. I also became a forensic technician at laboratory. I also became dealing with being a teacher at high school. I also formed part of investigator at IPIT that investigates the police. So currently I'm a lawyer by profession. We are adjudicating at Pretoria High Court. So the curriculum for today, I'm going to talk about business compliance. I'm going to talk about business compliance on how companies and businesses must comply with the law. So, in order to comply with the law, firstly we have to understand what is a compliance. You cannot comply if you don't know what is a compliance. So a compliance, it means that companies or businesses must comply with statutory requirements and obligations. What are those statutory requirements? When we talk about statutory requirements, we are talking about the laws that govern the business or statutes that govern the business. When I say the law or statute is the same thing that govern a business. When we talk about obligations as a director or entrepreneur, what are those obligations? When we talk about obligations, we're talking about the duties that is expected from you in order to comply with the law. So firstly, we have the highest law in the land, which is the Constitution of 1996. Why is it the highest law in the land? Is because of it contains the Bill of Rights. It contains the fundamental rights. Remember, we are South African citizens. We have the rights. So where do we find those rights? From the Constitution. The Constitution as well, it stipulates how the country must be governed. So now, when you run a business or a company, you are exercising your right in terms of Section 22 of the Constitution, which is right to freedom of trade and occupation. The right of freedom of trade and occupation is your right that is stated in Section 22 of the Constitution of 1996. So when you exercise your right, it means that you have to open a business, you operate. So in order for you to open a business, you'll have to decide which business you want to open. So we have a different types of businesses. We have a private company, which is PTY Ltd. We recognize a private company by way of PTY Ltd. You'll have to decide which company you want to open. We also have a sole proprietorship, which is the company that you open alone. So what's the difference? The difference is that when you operate as a private company, the private company enjoys a perpetual succession. What does it mean when we say it enjoys a perpetual succession? It means that even if you don't exist, the company continue to operate. If you die, someone else will take over the company. That's a perpetual succession. And also, in an event of insolvency, if the company becomes insolvent, when I say insolvent, it means that you are unable to pay your debt. So they will liquidate the company. They will only take the assets of the company. You, as an individual, you are protected. But if you operate as a sole proprietorship, that means there is no distinction between your personal assets and the company assets. So a sole proprietorship is operated by the one person. That person, it means if the company is liquidated, the sole proprietorship, they will have to sequestrate the person. What does it mean when we say they will have to sequestrate the person? It means that that person, they will have to take the assets, sell them, they will have to take his or her own assets and sell those assets in order to pay the debt. So that's the difference between the two. We also have a partnership. You'll have to decide which company you want to open or a business that you want to run. We also have a partnership. The partnership can be 2 people, can be 3 people, or 4 people. So when you operate as a partnership, it's also dangerous because of you share the profit, you also share the losses. And also, if one partner resigns, the partnership must be dissolved. It's no longer in operation. And also, if one partner dies, the partnership is no longer in operation. So, with partnership, you always have to know that you rely on each other with your partner. We also have another company, public company. A public company, mostly we don't open a public company. It's other people who open public companies. But us, in a local department, we rely on private company, we rely on sole proprietorship. We also rely on a personal liability company. A personal liability company is the same as private company. The difference with the private company and personal liability company is that a private company, we see it with a PTY Ltd, which is a proprietary company. With personal liability company, we see it with the words INC, which stands for incorporated. So that's the difference between those various companies. So you'll have to decide which company you want to open. So once you have decided which company you want to open, now you'll have to know the law that governs the company specifically. Remember, we spoke about the Constitution. The Constitution is the supreme law of the land. It's the highest law in the land. In South Africa, the Constitution. So, with the Constitution, we have our rights. We enjoy our rights from the Constitution. The right to freedom of trade and occupation is stated in Section 22 of the Constitution. Now, you open a company. When you open a company, we have another law that governs that company, which is Companies Act 71 of 2008. Companies Act 71 of 2008 is the law that governs companies. It states the manner in which the company must be registered. It states the manner in which you as an entrepreneur or a director, you must operate. Section 14 of Companies Act states that you must register a company with CIPC. So CIPC is the one that is responsible to register your company. You receive the documents, relevant documents, memorandum of incorporation, notice of incorporation, certificate of operating, you understand? So that's the first step to comply with the company. So now, there are some companies that you can open, but those companies that you open, they need extensive compliance. When I say extensive compliance, it means that you don't only have to register with CIPC. Example, if you want to be a machinist, you have to register as a credit provider. If you want to be a machinist, you can't just operate without registration. You must register as a credit provider. Which law states that you must register as a credit provider? Section 40, subsection 1 of National Credit Act 34 of 2005 states that you must register as a credit provider in order to lend people money. You understand? So you can't just operate without registration. So now you can register as a PTY Ltd at CIPC, as a loan shark. Then now you have to register as a credit provider. Where do we register as a credit provider? National Credit Regulator in Midrand is the one that governs the registration of machines. You understand? So the reason that you must register, as maybe you want to run the business of machines, if you want to register, the reason is because of if you lend someone money, maybe let's assume you lend person 10,000. That person doesn't want to pay you back. Now you take that person to court. You want to get a court order to get your money back. But before you take that person to court, you have to give that person a letter of demand, which no, give me my money. If that person doesn't comply with a letter of demand, what you do, you take them to court. But if you are not registered, you know what they will say in court? That 10,000, the transaction of that 10,000 will be declared null and void because of why you're operating illegal. You understand? So those are the legal implications. That transaction won't be recognized because of you're operating illegal. Which law are you contravening? Section 40, subsection 1. You contravene it because of it states that you must be registered. So, another company that you want to operate, if you want to sell food, you must have at least a certificate of acceptability. That's one of the requirements. You sell food at the premises, you must have a certificate of acceptability. So that certificate, it confirms that the authorities inspected your food and your food passed the test of hygiene. Also, your food is healthy and safe to be digested. So those are the some expensive requirements that are needed. And also, if maybe you want to sell alcohol, we all know, if you want to sell alcohol, you must have a liquor license, whether it's on or off consumption. If it's on consumption, that means that license is only regulated with you only sell they only drink inside, you don't go with alcohol, you don't go with restaurant, bar, clubs, you don't live with alcohol. With off consumption, it means that you can buy and live with the alcohol. So those are some of the expensive requirements. Those are some of the expensive requirements. Now, you open the company, any form of the company, any company of your choice, you open the company. Now, you know what you should do when you open a company. You'll have to protect your logo. You'll have to protect your slogan. You'll have to protect your brand name. You'll have to protect the names that depict your goods or services. So it's very important to know that Trademarks Act 124 of 1998 is very clear that when you want to protect your logo, when you want to protect your slogan, you must register a trademark. You must register a trademark. Because of the law, it tells us that you must register a trademark. Which law is that? Trademarks Act 194 of 1998 is very clear to that you must register a trademark. So again, if maybe you are, remember, I'm just talking about compliance, on how to comply with the law, on how to protect your ideas, on how to protect your product or goods and services. Now, if maybe you invent a product, if you invent something, also it must be registered. That's called a patent. If you invent a product, you must register it as a patent at CIPC. So it's very, very important to be familiar with the law when you run a company. Don't just run a company unnecessarily. You have to do a research. Also, where does this take us from? It takes us from trademark and patent. Then leads us to Copyright Act. So a Copyright Act also is very clear. It's very clear. Copyright Act 98 of 1978 is very clear to tell us that it is automatically registered. If now you are in a music, you write a song, it's automatically registered. If now you write a book, it's automatically registered. But how is it automatically registered is the question now. What you have to do, you just have to write the words copyright, or write the words copyright reserved, or write the symbol C. Then you write your name. Let's just say you wrote a book. You write the symbol C, you write your name and the year in which the book was published. That's a copyright. But you can only register a copyright if you have a video. If there's a music video or a film, you're acting a drama or something, you can register a copyright. We all watch drama and so forth. If we never let some drama you can see at the end they say copyright reserved. So that's the law. Copyright is very clear on that. So now we move. Remember, you are running a business. Compliance is long, guys. There are many laws that govern compliance. And with compliance, you are protecting yourself you are also protecting the company. So now you're operating. Remember, you registered the company from CIPC. When you register a company at CIPC, SARS automatically is registered. You get a company input tax number. That shows you are running a company. What you have to do, it means that you'll have to do your annual returns, do the e-filing. If you register the company, that company doesn't operate, make sure that you file a zero returns. Don't just see it in your time, that company doesn't make income. No, I don't do e-filing, I don't do any annual returns. No. You know what they will do? SARS will investigate you. When they investigate you, they realize, oh, you are owing us. Remember, if you don't file an annual returns time years, there are fines. You understand? There are fines and penalties. So they just You know what they will do, SARS? They don't have a problem. They'll just come to you. They send you a letter of demand. Remember, if someone is owing you, the first thing that you will have to do, send a letter of demand that states all the details there. Then you receive that letter of demand that you owe SARS. You'll be surprised, how do I owe SARS? You forgot that you open a company that doesn't operate. You forgot. Now you find yourself in a situation you're owing 17,000. You are not even working. You know what they do? They realize that this one is not working. They sequestrate you. When I say they sequestrate you, they attach the assets. Any assets that you are owning, they attach those assets, then they do what? They sell them so that they can get their money. That's a sequestration. You understand? So it's very, very important to comply with these statutory requirements. Do the research. You'll find all the information. Information is free on the internet. You can get all information anytime. Now, you run a company. Remember, you must comply. You run a company. When you run a company, you have a fiduciary duty as a director. What does it mean when you say you have a fiduciary duty? You have a duty to act in a good faith. Section 76, subsection 3, paragraph A of Companies Act is very clear to mention that when you run a company, you must exercise your duties with fairness. You must also make sure that when you run a company, you take a responsibility, you exercise your duties with a reasonable person's test. What does it mean that you must exercise your duties with a reasonable person test? It means that you must take all the necessary skills that you have to ensure that you provide a good provision of services, and you make sure that you provide a quality services. Because remember, you are a director. When you are a director, you must make sure that you provide a quality service. If you don't provide the quality service, you know what they will do? They will sue you for professional negligence. You understand? They will sue you for professional negligence because you said you're a director, you can do this specific task or a specific project. Now you're failing to do it, they sue you for professional negligence. So it's very, very important. Because of even the clients of the customs are protected. Clients or customs are protected. Normally we call them consumers, those who buy your goods and services. They are protected. Which law protects them? The law that protects them is Consumer Protection Act 68 of 2008. It's very clear. Section 54 states that as a client, you can demand a good quality service. Section 55 says that you as a director, you must make sure that those goods are of good quality. Section 56 of the same act says that if those goods are defective, there is R. You replace, you repair, or you refund. That's section 56. It's not me, guys. It's section 56. It's not me who says it. It's the law. So I'm just giving you what it's saying. It's not me. It's the law. Even if you can check now, you check section 56 of Consumer Protection Act 28 of 2008. You'll see 68 of 2008. You'll see. It's very clear. So now, you must make sure that you provide quality service to the client. You must make sure that when you operate as a director, or you operate alone, or you operate as a PTO-LTD, you must make sure that you apply the principle of corporate social responsibility, CSR, corporate social responsibility. What does it mean? Corporate social responsibility is very clear to mention that the companies that are operating in the communities, they must improve those communities. They must ensure socio-economic development. You don't just have to operate without considering the community. It's the law, it's the principle. Corporate social responsibility means that you, as you operate as a director or running a company, the community must benefit from that company. How do they benefit? Through a community service. Give people community service. You are improving the socio-economic development. It's very clear. It's very, very clear on that. So now, remember, you're running a company. Now, when you run a company, you don't have a, let me just say, you run a company, you get sponsors. When you get a sponsor, or maybe let's assume that you want to get a loan from the bank or any financial institution, you must have a good understanding of law of contract. Law of contract is very, very important. There is no way you can make deals without law of contract. If you can make deals without law of contract, I don't know what to say, but it's very, very dangerous. You lose a lot of things. A law of contract is very, very important. It's a legal document that specifies the relationship between service provider, a director, and the client. So now, with a law of contract, we know that some of us, we are not legal minds. We don't understand the contract. Mami said earlier on that if you receive a contract, take that contract to the legal aspects to check and confirm the validity of the contract. Even on your own, you can do that. You can Google some of the terms there and check. When you receive a contract, don't just, because I know some of us, when we receive contract, we don't read that. We don't read the contents. So now, regarding an off contract, there are terms that must be there, or clauses. Now, we have essential terms. Essential terms, those are the terms that make the contract valid. Essential terms are the terms that make a contract valid. What are those essential terms? Essential terms, we talk about agreement. There must be an agreement. The contract must also stipulate your names, because we don't even know who are you contracting with. It must stipulate the names, and also it must be lawful, it must be legal, and also it must indicate the scope of the service that you are providing. That's essential terms. If that contract, you didn't sign it, it's not inoperative. If that contract doesn't have your name, it's not inoperative. Those are the essential terms. We move. We also have natural terms. Natural terms are those that apply automatically. I spoke about one earlier on agreement. It applies automatically. You don't have to include it. Lawful, it applies automatically. Formality, it must be, contract must be formal. It applies automatically. So, and capacity, you must be able to act according to that contract. The last term that must be there is incidental terms. Incidental terms, those are the terms you, as a director or entrepreneurship with the client, you must include. You decide to know, let's put this term, let's remove this one. Now, those are the terms that must be in a contract. There are clauses that are very, very important when you receive a contract. If you run a business, you go to a financial institution, maybe you run a business, you don't have a financial master, so you go to the financial institution to lend the money. They give you a contract. You tell them that you will pay with installments. They will give you a contract. It's not a problem. I guess they will deduct it from your bank. They will deduct it. So they give you a contract. When they give you a contract, you know what they include in that contract? They include the acceleration clause. What does it mean when we say acceleration clause? And this acceleration clause, it applies everywhere. Even maybe you buy a car with a bank. It's very, very dangerous. If you buy a car with a bank, that acceleration clause is there. What does it say, acceleration clause? Let's hear. Acceleration clause says that if you default one payment, the whole amount will become due and payable immediately. That's acceleration clause. So you must be very, very careful when you receive a contract. If you see that clause, you tell them to remove this one. Tell them. Because if you don't tell them, remember, you won't be able, if you maybe took a car with the bank, you are paying the bank is paying that car. You won't, there are difficult times. You will default one payment or two. Because you can't predict the future. So you can default. So tell them to remove it. It's your contract. You are not paid with it. Because that term is very, very important. If you default one payment, the whole amount becomes due and payable immediately, plus the interest. You also forfeit the money that you paid previously.
Yes.
So you must pay it immediately. If you don't pay it immediately, you know what they do. In fact, you must pay it immediately. They also repossess the car. You understand? So it's very, very important. Check this clause. We also have a restraint of trade. I also have a restraint of trade. A restraint of trade is very, very important. You as a director or entrepreneur, you are running a company. You hire someone. When you hire that person, that person he's working. La clashana when that person, you clash. It's a personality clash or any form of clash. That person resign and open the same business as yours. You understand? Because you have someone, after 2 weeks, someone is opening the same business 5 minutes away from your business. So in order to prevent that, include a clause that's called restraint of trade. A restraint of trade is a clause that prevents someone from using your trading secrets and prevents someone from using your trade methods and prevents someone from opening the same business that you open in the nearest place. So make sure, guys, if you run a business, every person that you hire, give them the contract. They will destroy you, those people. Make sure that you give them a contract that will bind them. So now, we also have another clause. We also have another clause which is called assignment. I'm not talking about assignment from school. It's a clause. Assignment, it means that if you are unable to meet the requirements of the contract, if you are unable to act according to the contract, you transfer the duties, the rights and obligations to another person to act on your behalf. That's assignment. You include it there. You can also include a clause called force majeure. That clause called force majeure means that if you are contracted with someone else, now there is an act of God, there is a natural disaster, there is maybe a heavy rainfall, there is a strike, or you have issues with transport. That force majeure protects you so that they cannot say that you breached the contract. Because remember, as a you must act according to the contract. If they say you have to deliver specific goods, you fail to deliver them, it's a breach of contract. If it's a breach of contract, they sue you for what? For the damages. So it's very, very important to include that clause of force majeure. So now, I'm slowly moving away from the contract. So, we also have clauses of ADR, which is alternative dispute resolution. We have 3 types of resolution. We have mediation, arbitration, and negotiation. You can include them there. Why are you including them? So that if there is a dispute arising from the contract, you can appoint a mediator, you can appoint a negotiator, you can even appoint an arbitrator to solve what? The dispute. You understand? So it's very, very important to include those clauses in the contract. Now I'm moving away from the contract. Now you hired employees. When you hire employees, it's very, very important to comply with the statutory law. Occupational Health Act 85 of 1993 is very clear that when you hire employees, if you have employees in the company, provide safe working conditions. Why should you provide safe working conditions? Why? Because of Section 24 of the Constitution. It states that everyone has a right not to be in a harmful environment. You must have a right to be protected from the harmful environment. So Section 24 is very clear. Remember, Section 24 is from the Constitution. It's your right that you have a right not to be subjected to the harmful environment. Your well-being must be protected, your health must be protected. So as an employer, if you are running a company of employees, please apply Occupational Health and Safety Act 85 of 1993. Provide safe working conditions, hygiene, practice hygiene as well. Also, you must also register COIDA at the Department of Labor. What does COIDA say? COIDA is a compensation for occupational injuries and disease act. That means that if someone is injured, sustained injuries on duty, that person who sustained injuries on duty must be protected by the law. But if you didn't register COIDA, you know what's going to happen? You know what's going to happen? You are not registered with COIDA. Someone sustained injuries on duty. You, as a director, you'll have to pay that person damages. You'll have to pay the special damages. The special damages are those damages, medical expenses, medical costs. You'll have to pay the general damages if motor so. You'll have to pay. But if you registered COIDA, it's very, very simple. Compensation fund will pay. Compensation fund will pay. So it's very, 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 very clear to deal with those circumstances. Now, also, as an employer, make sure that you practice Basic Conditions of Employment Act 75 of 1997. It's very clear, Basic Conditions Employment Act 75 of 1997 is very clear to mention that there are working hours, there are leaves, there is lunch, there is overtime. So make sure you practice that. Don't just operate without complying. Practice those hours there. They are there. I can't mention them. They are there. Just check Basic Conditions Employment Act. It's clear on that. And also in a workplace, practice equality. I know in a workplace whereby you're operating, you have employees. If you have employees, some employees are not treated equal. You understand? So Employment Equity Act is very clear that you must ensure equal treatment towards your employee. So now I'll be dealing with the last law so that I can close. I'll be dealing with the last law. Which law is that? Labor Relations Act 66 of 1995. Labor Relations 66 Act of 1995 is very clear that there must be a fair dismissal. Don't just dismiss someone when it's someone. No. You can't do that. They will take you to CCMA. And when they take you to CCMA, you know what they do? They reinstate that person and you have to pay the damages as well. You pay even the cost of that matter. So it's very, very important that Labor Relations Act 66 of 1995 states that there must be a procedural and substantive fairness. What does it say when there must be a procedural fairness? It means that you must communicate with the employee, allow employee the principle of audi alteram partem. What does it mean when it says audi alteram partem? To hear the other side of the story. Also, apply substantive fairness. Is there any rule in the employee that employee in the employment that employee contravened? If there is a rule, yes, you can dismiss that person. You have to meet the requirements of procedural and substantive fairness. If you didn't meet this requirement, it's automatically unfair dismissal. So it's very, very important. Also, you can dismiss someone based on operational requirements. What does it mean when you say operational requirements? Operational requirements, it means that there are economical issues in a company. The company doesn't have any enough money to pay you as an employee. Those are the economical needs. You can speak to the employee who say, wait, who will know? At least take a cut or leave, you understand? We also have other requirements called technological needs. Technological needs, if maybe you have a chance to do the work, you don't need employees, you can dismiss them. So I will just end here, guys, because if I don't end here, I'll talk the whole day. You understand? So compliance is very, very long. I didn't mention everything because of it's long, and we're running out of time. So let's make sure that we comply with the rule of law. Let's make sure we comply with our constitution as supremacy of the law. Let's make sure that also we have our own rules, the company. Company must also have its own rules called subordinate legislation or secondary legislation. You can have your own rules, but if you have your own rules, those rules must not be inconsistent with the constitution. Those rules must not be inconsistent with Companies Act 71 of 2008. You understand? So also make sure that you build the value you serve people, then people will pay for your value. Thank you.